Depriving criminals of their ill-gotten gains is clearly a desirable goal for society. The challenge, however, says our next guest, is to do that in a way that protects the rights of innocent property owners and discourages abuse by law enforcement agencies. Fact is, that can be a problem, but some states are leading the way in trying to prevent it. Jon Guze is Director of Legal Studies at the Locke Foundation, and he has just released a new report on what is technically known as asset forfeiture. Jon, welcome back to the program.
Thanks, Donna.
First of all, North Carolina does have a law about this issue, and it protects us, but you say that that's not enough. Help us understand where North Carolina is on this issue.
Well, our asset forfeiture laws are actually among the very best in the country. Under North Carolina's criminal forfeiture statute, before property can be taken from somebody who's suspected of having used it or acquired it through a crime, that person has to be accused and convicted, and it has to be shown that the property really was connected with the crime in some way. That's very good. That protects the innocent, and it also discourages abuse. And another factor that discourages abuse in North Carolina is this: law enforcement agencies cannot keep the property or the proceeds from property that they acquire through forfeiture under North Carolina law. Instead, the proceeds have to be used for public education. That's very good because it takes away the incentive to abuse the system, which has been a huge problem in many other states.
And in fact, in your report, you do point out that North Carolina actually leads in terms of protections, but that the federal government has some other laws and some other ways of doing things that allow, in some cases, law enforcement agencies to kind of skirt North Carolina law.
That's right. It's called Circumvention, and the way it works is this. Under a program called equitable sharing, state and local law enforcement agencies can use federal law to process seized assets, and then they get to keep all or part of the proceeds from those forfeitures.
Jon, is this a problem in North Carolina?
Well, I don't think it's a problem. At least if it is, it's not a huge problem. We've looked, and we haven't really found very many instances in which this process has been abused by North Carolina law enforcement agencies. There's been a few, but overall, all law enforcement agencies have maintained their integrity, and part of the reason they have, where other states have slipped into abusive police practices, is because we have these good protections under North Carolina law. What we think is important is to ensure that law enforcement agencies in North Carolina aren't tempted to use this federal anti-circumvention process as a way to get around North Carolina protections and in that way be led into bad and abusive practices.
Help us understand how the federal law works. Under what circumstances can a law enforcement agency in a state actually work with the feds?
Well, there's actually two ways state and local law enforcement agencies can take advantage of equitable sharing. The first way is if they're involved in some kind of a joint task force or a joint investigation with a federal agency. When that happens, if property is forfeited under federal law, that property gets shared, or the proceeds from selling that property actually gets shared between the feds and the state agencies according to a formula that's based on how many hours each department has worked and so on. That's one way. The other way is through a process called adoptions. Now, the adoptions program really exist only for one purpose, and that is to circumvent state laws. The way adoptions works is state law enforcement agencies can seize property, and instead of processing it under state law with all the protections provided there, they can simply have it adopted by a federal agency, perhaps by the Department of Justice or the Department of the Treasury. It'll get processed under federal law, and then they get 80% of the proceeds back. The feds weren't involved in this law enforcement operation at all. Their only job was basically to launder the proceeds through the federal system, and they keep 20% for their services.
Now, I'm not an attorney, and I'm not in law enforcement, but when I hear you describe those two ways, Jon, the first one, the joint investigations, frankly sounds okay to me. It sounds like you've had the federal government and a state or local law enforcement agency work together to try to get a bad guy off the street, and then the assets that were used as part of that criminal activity, they've split the proceeds. Does that It seems fair.
It is. Well, let me look at it a different way. Certainly, everybody wants state and law enforcement agencies to be able to cooperate with the feds when there's a law enforcement purpose in doing so. And one of the difficulties that states have had in trying to frame anti-circumvention legislation is to do it in a way that doesn't prevent that. So everybody agrees we do want joint investigations. We do want our agencies to work with the feds. The question is, what happens if there's assets seized in the process? What we don't want is that for a joint investigation to be an opportunity for state and local law enforcement to circumvent the state laws. And that's what some of these other states have come up with ways to avoid that.
Let's talk a little bit about that, because I know you're going to be writing another report here shortly about North Carolina and how we can address this issue in our state. What have we learned from other states? You've come up with 3 particular lessons, and one is this: to ban or severely restrict federal adoptions, because that really, you're zeroing in on that adoptions process.
I am, for a couple of reasons. The main one is that there's simply no legitimate purpose for it. Adoptions serve only one purpose, and that's to circumvent state law, so that we don't need them. If somebody suspects that a property has been used for a crime, they can seize that property and they can forfeit it under state law. There's no reason to go through federal law other than the fact that if they go through federal law, they don't have to charge or convict the property's owner. They don't have to show a nexus with the crime, and they get to keep the proceeds. That's very important. If they process it under state law in North Carolina, the proceeds go to public education. If they process it through the federal system, they get to keep those proceeds.
And no one would want a profit motive to become high on the priority list when you're talking about public safety and law enforcement.
Absolutely not. What we've seen in other states where they don't have the protections we have here is we end up with what I call predatory policing. It turns the police into predators, and it turns the public into their prey. That's the opposite of what we want from law enforcement.
That's lesson number 1. You also write about this recommendation: don't divert forfeiture proceeds away from law enforcement.
Yes, the reason we don't want to do that, I mean, at first glance, you might just think, well, let's just insist that the same thing happens as happens under North Carolina law. Even if they process it through federal law, they still have to turn it over to public education. That won't work, unfortunately, because there's federal rules that say forfeiture proceeds can only be used for law enforcement purposes. Now, I'm sure that rule was put in place thinking that it was a good idea, but what it does is it prevents the best way of protecting the public in North Carolina. So other states that have done this have found that once they've put that kind of rule in place, the feds won't cooperate with them in joint investigations. We don't want that.
And John, you also write that some states have been trying to experiment with what are known as minimum thresholds in order to figure out exactly when to get involved in this type of thing and when not to. How does that work?
That seems to be the most promising approach to continuing to cooperate with the feds in joint investigations, but avoiding the possibility of abuse. And the way these thresholds work is they say if the forfeited amount is below a certain threshold, either you can't send it to the feds or you can't keep the proceeds. Both ways have their advantages and their disadvantages, but since the vast majority of forfeitures are for small amounts, putting in a threshold protects a lot of people. But because most of the actual revenue comes from the large forfeitures, it doesn't jeopardize the process.